Okay, Mr. Chavez, you are now live.
Thank you, Mr. Moya. Good morning, folks. We are on the record. I'm Stephen Chavez, the city's land use hearing officer. Today's date is October 29th, 2020. This is a quasi-judicial appeal hearing, an appeal from the ZHE, I believe. Actually, it's two appeals from the ZHE, and they are AC 20-10 and AC 20-11. Both appeals have been consolidated because they stem from the same parties, the same facts, and the same issues, I believe, and the same decision of the ZHE. So as you all know, we are under public health orders from the state because we have a pandemic that is making its way through the world. Because this is a time-sensitive appeal, we have switched to a Zoom format for all LUHO hearings, land use hearing officer hearings. So to prevent background noise, please mute your speakers when you're not speaking through the Zoom program, not through your computer. And you will most likely be muted automatically after you finish speaking by Mr. Moya. If you wish to speak, you can either raise your hand to let me know or unmute your speaker on the Zoom program, and then politely interrupt me. Please turn off your computer cameras because this will prevent lag time on your end in case that develops. This hearing is also open to the general public, and people can watch it via the city's YouTube channel as it is occurring. Actually, I'm not sure if it can be watched as it is occurring, but it will be on the city's YouTube channel. This hearing is also being recorded by a certified court reporter, so there will be a certified transcript of this hearing. Now, beginning with the appellants, please make your appearances for the record. The appellants?
Yes. My name is Stephen Benz, representing Los Altos Neighborhood Association.
Mr. Benz, do you spell your name with a V or a PH?
PH.
Okay, and you're representing the Los Altos Neighborhood Association, sir?
Correct.
Okay. Let me swear you in now. Can you please raise your right hand? Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Thank you, sir. Is there anybody else that is going to be speaking in this appeal that you are aware of?
No.
Okay. Okay. And are you representing the appellants on both appeals or just one appeal?
Yes, both appeals.
Okay, thank you so much. Now, are there any, well, I should ask the party opponent. Mr. Chavez, can you please introduce yourself and name the person at your right?
Angela, why don't you introduce us?
My name is Angela Williamson, and I'm the agent for the property owner and for Murphy USA. And this is our legal counsel, Mr. Morris Chavez.
Okay. Good morning. Good morning, Mr. Chavez. Good morning. And I'm sorry, Miss Williams Smith? I didn't hear that.
Williamson?
Williamson. Okay,
Yes.
I apologize.
That's okay, thank you.
Miss Williamson, are you an attorney?
No.
Are you going to be testifying in this matter?
Yes, sir.
Okay, let me swear you in right now. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
Yes, sir.
Good, thank you so much. Now I can hear everybody much better. The background noise has stopped on my end. So, okay, so are there any preliminary matters beginning with the appellant? Mr. Benz, any matters regarding new evidence or issues that you would like to deal with the procedural posture of this case?
None that I'm aware of. I think we've presented our case in a couple of files, and that suffices.
Okay, thank you. Mr. Chavez, and by the way, there is no relation between myself and counsel for the party opponent, Mr. Chavez. Mr. Chavez, are there any preliminary matters that you would like to submit in the record?
Yes, here now, Sir Chavez. I was going to bring it up under our presentation, but if I have the opportunity now, there's a few letters, two from realtors and a letter from Chairwoman Linda Lopez from the New Mexico State Senate. And it would be new evidence. It wasn't brought forth during the earlier hearing. And basically my argument is going to be that the probative value of this information is significantly outweighed by its prejudicial effect.
Okay.
And the reason why is, one, I think the letter from Senator Lopez, who I have a tremendous amount of respect for, is political in nature. It talks about incident numbers of which we don't have. It talks about support of Mothers Against Drunk Driving, which we can't confirm. The letters from the realtors, in particular, Natalie Lujan makes a statement that research has shown that not only is there an increased level of airborne chemicals within 100 feet, but also affects the quality of life. We don't have access to these numbers or this information. So obviously you can let these in. By all means, you're allowed to do so, obviously, but just we want to make note of the probative value is significantly outweighed by its prejudicial effects, sir.
Okay, Mr. Chavez, thank you. I have reviewed those, and I had a note to myself to ask the appellant regarding these letters. It looks like one of them is at least dated the 17th of September 2020, so it's subsequent to the ZHE's final decision in this matter. The other two, I don't believe, are dated.
Mr. Chavez, two of them are dated.
Okay, right.
The 17th, correct.
Miss Ferdon and Miss Lujan's are dated, and there's a third one that's not dated. No, I'm sorry. Miss Lujan is the one that's not dated. Miss Ferdon and let's see, the other one is, oh, they're both from Miss Ferdon. Ann Ferdon and yes, okay. So there's two letters from Ann Ferdon. Those are dated, and then the third one is from Miss Lujan that is undated. I reviewed those letters, Mr. Benz, and I normally allow, and I'm very flexible with hearsay evidence in these quasi-judicial hearings. I think the rules require me to be flexible under state law, under state case law, and under the rules for these hearings. I have a problem with these letters because although they purport to state that they are experts in the field of real estate, or at least that's what they suggest, they don't state with any particularity whether or not they are actually experts in the field, number one. Number two, they haven't even met the preliminary foundational requirements of experts. That is, they didn't explain to me what the basis of their opinions. I mean, they explained to me their opinions, but I don't know what that opinion is based on. I don't know the analysis that was conducted to support the opinion. And normally experts, when they submit materials in LUHO records, such as engineers, they form the basis for those opinions, either in the document or in testimony. Mr. Benz, do you have these realtors to testify in this matter?
No, they're not present.
Okay.
All I can say is that we as a neighborhood association, non-professionals in these matters, of course, donating our time and money and giving up vacation days to do this sort of thing, did the best that we could under short notice to gather evidence and statements and present them to you.
And I understand that, Mr. Benz. I understand that you're not an attorney and you don't know the issues, the legal issues with regard to these what purport to be professional opinions. I will leave them in the record, but I will note to the City Council my recommendation regarding these letters. And my recommendation is that to the City Council will likely be that this, with regard to these three letters from the real estate industry, that they do not meet the standard for professional expert opinions, because they did not form the basis of those opinions, and they did not explain to me why they consider themselves experts in this field. Those are essential issues for experts, in my opinion. With regard to the political letter, I agree with you, Mr. Chavez. The letter is political. I'm going to keep it in the record, of course, for the City Council to judge it, and I will do the same with that letter. It's a political opinion, I believe. It's an opinion from a layperson, just as many of the facts and evidence in this case are. And so it's given the weight it deserves as an opinion. Are there any other matters, Mr. Chavez?
None at this time, Mr. Hearing Officer.
Okay, let's proceed, Mr. Benz. I'm really flexible with time in these matters, so take your time, but within reason, take your time, okay?
All right, thank you. Yes, as I said, we've presented the case in writing, so we hope
And I've read the entire record, sir.
that will suffice, and I'll just try to highlight a few things here, and then we can continue with the discussion. So first of all, of course, thank you so much for your time and attention to the Los Altos neighborhood appeal of the conditional approval of Murphy Oil building a gas station and mini market with beer and wine sales on the northwest corner of Bridge and Old Coors. So in this discussion, I will refer to the successful petitioner for conditional approval as Murphy Oil, rather than their agent Modulus Architects in Land Use Planning. By way of introduction, I'm Stephen Benz, and along with several other members of the neighborhood, including our neighborhood association president, Athena LaRue, I've worked on the written appeal that led to this hearing. Athena, our president, just started a new job and is in mandatory training today. And my partner, Jennifer Kepish, was originally going to make this presentation, but as is the case with so many people for whom this is not a full-time job, the timing of this meeting conflicts with her job as a teacher, and so I've been asked to present on behalf of the neighborhood. So in a nutshell, our appeal is that allowing such a business to be built at this location will harm the surrounding neighborhoods and the city as a whole by increasing dangerous traffic patterns at an already dangerous intersection, by increasing serious crime on site and in the nearby streets, by adding constant air pollution, by threatening groundwater, by making nearby resident properties unmortgageable, by degrading the character of the neighborhood, and by causing harm to established businesses, and by making it less likely that desirable businesses will locate nearby. Murphy Oil, as the petitioner, was required to meet decision criteria to show that the known harms of its business would be offset by benefits it would bring to the neighborhood, but did not, we submit, do so in its petition, instead making unsupported assertions about benefits that are not borne out by any data, including their own. Because it did not meet the burden of proof and because the business would do real harm, we request that the conditional permission be rescinded. So my partner, Jennifer Kepish, a teacher, as I said, of 4th and 5th graders, worked on this appeal, and she wrote a little statement that I'd like to read because I believe it's, in a philosophical way, summarizes our position. She writes, "I am a resident of the Los Altos neighborhood, which is a very small neighborhood on the northeast corner of Old Coors and Bridge. I'm not an expert on planning and permits. I'm an elementary school teacher, and it is from this perspective that I want to enter my remarks today. Every year, I teach my 4th and 5th grade students about ecosystems. I teach them that an ecosystem is a mix of many things: the type of soil and the amount of rainfall, the elevation and the latitude and longitude, the microbes and the plants and the animals. I teach them that even small things and even ugly things contribute to how the ecosystem thrives. I teach them that removing an apex predator like a wolf might seem like a good idea, but that it can result in overpopulation of grazers, erosion of the soil, lack of food for smaller animals, runoff in watersheds, along with other negative consequences. Introducing one non-native species, such as the salt cedar, can alter the availability of water and minerals for native plants. And over just a few years, a thriving ecosystem can be changed dramatically. Therefore, humans who try to take care of land have to be very careful about what they add and take away from an environment. A small change may push a delicate system far out of balance." So we appreciate, and returning now to my statement, we appreciate that those of you who work in planning are in many ways stewards of the delicate ecosystems that comprise the interconnected neighborhoods of our city. We know that there is an important balance to be found between promoting economic development and discouraging crime, between raising revenues and lowering home property values.
I apologize for interrupting you, but you know, I want you to use your time wisely, and I know you haven't done this before, but this is not a rehashing of the issues that were before the ZHE. This is an appeal, and so the standard for an appeal is whether or not there was error, whether or not the ZHE erred in the facts, in the law, or in the policies of the comprehensive plan, or in his decision, essentially. So those are the only issues for me. I am not here to step in the shoes of the ZHE and subjectively, decide this matter. I have to look at the objective facts and the law, and that's my task. And it's a very restricted role in these matters. I take it very seriously. So, I mean, it's your burden to show me how the ZHE erred. And so I'd like for you to spend your time on that.
All right. I apologize then for that.
No worries.
So in that regard, just give me a second here. All right, I'll just read this little section here, which I think addresses that, maybe not in the most direct fashion, but does address what we consider to be the errors in the decision. So we'll go with that. All right. There are three important aspects that form the basis of our appeal. First, Murphy Oil petitioned to be allowed to sell alcohol at the location. The conditional approval permitted beer and wine sales. We believe this approval should be overturned based on inaccurate and misleading information suggesting that there are few places to purchase alcohol nearby. And as we presented in our appeal, there are numerous places to purchase alcohol nearby, in contradiction to the statement by Murphy Oil in their application. Second, the application for the businesses that Murphy Oil wished to conduct required that Murphy Oil prove its presence would provide such major benefit to the nearby community that its obvious negative consequences for neighbors sharing the property line could be deemed an acceptable harm by the city. These negative consequences include increased crime, less enjoyment of property due to odor, light, and noise, lowered property value, and continuous exposure to harmful pollutants in close proximity. We do not believe Murphy Oil proved this, and we would like to call particular attention to the fact that FHA mortgages are not allowed on properties within 300 feet of a gasoline storage tank of 1,000 gallons or more, and that there are several properties that line the proposed Murphy Oil station that would be within that zone. And that is a significant harm that I think needs to be addressed by the city. Third, we contend that Murphy Oil did not.
I apologize, Mr. Benz. Let me stop you there. I read that, and it certainly perked up my interest in some of these issues. The citation is to the HUD handbook,
Yes.
Valuation Analysis for Single Family 1 to 4 Unit Dwellings. I don't find what you're purporting to tell me that this valuation analysis states. I didn't find that language. Can you tell me where in that HUD handbook that there's a statement that would prevent FHA to lend money for mortgages for homes that are within a certain distance of a gas station or a gas station tank?
Yes, our direct quotation comes from Community Environmental Defense Services website, which works on these issues. And that's what is quoted in the appendix to our appeal. So that's their language that is highlighted that says Federal Housing Administration insured mortgages are not available for properties located within 300 feet of tanks capable of storing 1,000 gallons or more of gasoline and other flammable explosive materials. And they, according to that website, the restriction appears in section 2-2M of the HUD handbook valuation analysis. So that's all I can tell you.
I saw that, and that's why I went straight to the horse's mouth, which is the HUD handbook, and I didn't find that. I'll look again. Maybe it's a different version. Is there a version that I should be looking at? Can you tell me? Did you look that up yourself, or?
I cannot tell you that. I relied on this organization and their statement. And all I can say is that on the view of the neighborhood association, and I think probably the city as well, is that's a significant point that needs to be determined before this goes forward, before this project goes forward.
Thank you. And just let me remind the parties about something before I forget. I apologize, Mr. Benz, you have plenty of time. This record, at least for AC 11, is not bait stamped. And so I'm going to bait stamp it myself from number 1 through number 293. Just for your reference, Mr. Chavez, I will include that in the record to the City Council, and you'll be able to request a copy of it. Both Mr. Chavez and Mr. Benz. It'll just include the bait stamping, which should have been in the record. Okay? A little housekeeping, I apologize. Go ahead, Mr. Benz.
All right, and then there's a third point involves Murphy Oil. We contend that Murphy Oil did not appropriately address provable harms to nearby residences and businesses if it builds and conducts the operations it petitioned for. And then we'll go ahead and name these as clearly as we can and explain why we think Murphy Oil did not address them and indeed cannot address them to satisfy their burden of proof. And then a fourth point involves traffic in the area and the number of entrances, merges that will be added to the flow of traffic in that area. So to review those points, or at least to go over our interpretation of them, I'll enter the following into the record. Regarding the sale of alcohol at this property, as I noted when speaking of previous applications, well, I didn't get that chance to say that, but there have been previous applications for alcohol sales on the 2 south corners of Bridge and Old Coors. The county, Bernalillo County, has found in each case that alcohol sales in this location would cause unacceptable harm to the community, and requests for alcohol license at the location was denied by the county. The county.
Can you tell me which cases were that? Were those with their Circle Ks, or?
Yes, Circle K has tried in 2 occasions on opposite corners of that intersection.
Didn't I handle one of those Circle K matters for the city of Albuquerque? Maybe Mr. Chavez knows. Mr. Chavez?
I believe you did, Mr. Hearing Officer.
Mr. Benz, are you familiar with that one? And the city found that essentially very different from what you just stated. The city found that they didn't meet their burden of proof. And I recall that. I actually went back and looked at the my recommendation to the city council on that one. And it was a terrible application. The applicants didn't seem to put their 2 cents into it. They just kind of threw it haphazardly, while the appellants had submitted literally hundreds of pages of analysis, studies that were not site specific for that location, but they made the links that were necessary to link those studies from other states and other municipalities with the issues that they argued in that particular case. And so the applicants did a poor job, and the appellants did a really strong, put together a very strong case in that matter. So that's why I recommended that it be that application be denied. And I think it was a reversal of either the Board of Appeals or the EPC. I'm not sure about that, but anyway, I'm just digressing. I apologize, but I think that was the reason. It wasn't because there was a finding of harm. It was because they couldn't establish no harm or mitigation. They failed to put together a record which I could review. So anyway.
Yeah, so that's one corner, which I believe is it's a very complicated corner because the city and county border right there. So on one side, yes, it was the county denied the Circle K's application to transfer a liquor license to that location. There's a church, in fact, bordering the property. So once again, I think it was not very well thought through, since that was within the number of feet that the county requires separate church and alcohol sales. This, of course, is on the opposite side and on the city side.
Is the church still there?
The church is still there, yes. It's an evangelical Hispanic church. So a non-traditional, I guess you might say, and perhaps easily overlooked in that because it doesn't have what Americans think of as a church steeple and the usual thing. It's more of a storefront, but it's fairly large and active church. All right. So I think the point that we're dealing with here in terms of alcohol is in its petition for alcohol sales, as we understand it, we could determine from it in the short time that we had to look at this. Murphy Oil claimed two things. First, that the area had only one point of sale for alcohol within 1.5 miles. And second, that in general, Albuquerque's average number of points of sale for alcohol are 6 times as dense as in this area. So we believe that the first point is false because we have gone around and identified the various places that sell alcohol within a couple miles of this location, and we've identified those in the report. And as for the second point, we think that it's fairly simplistic use of data claiming that the average for all of Albuquerque applies to all neighborhoods, when of course the average involves places like Nob Hill and so on, which are very dense.
Mr. Benz, let me ask you a question regarding the statistics that you challenge. It seems to me that the argument was made in the written part of the appeal that the applicant's statistics are incorrect with regard to their void analysis, that there is more than one liquor sales establishment within 1.5 miles. But you didn't, or the appellants did not identify which use is actually contradicts their argument, because I saw that there is one according to the applicants. I don't remember which one it was. I'd have to go back in the record, but apparently there is one within 1.5 miles that exists. You're saying there's more than one within 1.5 miles?
Yes.
Which ones are those? Tell me if you know.
Okay, so Casa Liquors is on Bridge and Goff. There's a Chevron station on Old Coors between Bridge and Central, so approximately Gonzalez Street, that sells liquor.
What's the name of that one?
It's a Chevron station.
Chevron.
Yeah.
And these two are within 1.5 miles?
Yes.
Okay.
Those are the two closest. I don't have in front of me the map. I think we've included in the appendix, but another straight liquor sales store on Central is Sky High. That's probably just outside the 1.5, about 2 miles. Sky High Liquors.
Okay, but that's wouldn't be a misrepresentation of the facts, though. It seems to me that what you've argued is that there is more than one within 1.5 miles, because that's really the statistic that the applicants have used, and I think the hearing officer used that as well in part of his justification for accepting that void analysis. Mm-hmm. Am I correct or incorrect in that?
1.5 is the number that comes up.
Okay.
Correct. It seems to me a rather arbitrary number, but if that's accepted, then we can stick to those facts. I can go on to say that there are others in the approximately 1.5 to 3 mile range, but apparently that's not relevant, so I'll leave that. I would also note that there's another Murphy Oil that's open up, or it has just opened up, just on the edge of that, probably about 2 to 2.5 miles away. And apparently the liquor is being sold there as well. So then we're just going by the points that Murphy presented for the validity or the value of liquor sales in this area. That was that there were those a lack of opportunities to buy liquor in the area, which we've contended, and then the matter of the density, which we argue is something that can be easily misleading given the statistics that we have. So
no, I understand it. So I found the record where the argument was made about the statistics within the liquor licenses within 1.5 miles, and in the narration of that by the appellants, you claim that there's a Chevron station that serves alcohol or that sells alcohol within 4,500 feet of the proposed location. And this is at page 75 in a PDF file of the record of AC 1911. And then you say there's a Sky High liquor store, and you cite to a 1.45 miles distance. Now, is alcohol sold at this Sky High liquor store? It sounds like it is. It's called a liquor store. Okay.
Yeah, it's a pure liquor store. The two pure liquor stores are Casa and Sky High, the closest. And then I guess outside of this, just outside of this range we're talking about, there's a Kelly's Liquor as well.
Well, no, in the Kelly's Liquor states, according to the appellants at page 76, that it's within 1.3 miles from Murphy Oil using an odometer reading.
Yeah, we tried to verify with Google Maps and odometers those distances.
Okay, and then there's a Speedway gas station and convenience store. Is that a retail outlet to the best of your knowledge, Mr. Benz?
Yes, that is actually very close to the Kellys. They might be on the same corner or within.
And you cite that it's 1.35 miles from the proposed location.
That's right.
Okay, so and then there's a Walgreens store, and do they sell liquor retail at this Walgreens store?
That's right, they do.
Okay, and you state that it's within 1.3 miles of the proposed location.
That's correct. I did not do these odometer readings myself, but anything on here is according to people in the neighborhood who tried to conduct this research.
Okay. Okay, so looks like there's, according to the appellants, there's 5 liquor retail outlets within 1.5 miles, presumably. I'm sure the party opponents will have something to say about that, but I'm just trying to establish. So, do you stand on this? Is it this part of it? This is part of your appeal. I mean, you state that they misrepresented the facts to the hearing officer. Is that what your position is?
That's correct.
Okay. Go ahead, sir. And how, and I guess, and my next question would be, in your opinion, how is this, these new facts, or these facts, how do they relate to the appeal? I mean, what is the error in these? If the ZHE relied on these, what's the error?
Well, and I would say that that's partly, it depends on why the point was brought up in the first place. I mean, if that was a basis for Murphy Oil to contend that liquor sales should be permitted there, then all we're doing is saying that this does not appear to be consistent with the facts. We're just responding to what Murphy Oil has raised.
Okay. Thank you. Go ahead, sir.
Okay. So just summarize by saying, if the law is to be permitted alcohol sales, it cannot be because there's a lack of points of sale for liquor near it. There is no need to add another spot for a beer run in this area with its 7 established points of sale for liquor within a couple of miles, including the other Murphy Oil. Next, the decision criteria state that a business must, the decision criteria state that a business must show that it may cause harm, that if it may cause harm to a neighborhood, its worth must offset that harm to a high extent. And they require, the decision criteria require the business to prove this. So in our
that's not true, but that's generally true. But I think there has to be first a finding of material harm. It's not just harm. There has to be material harm, and I don't know what that means, but it sounds like it's a greater harm than just harm. And if there is that material harm that is found, then the mitigation has to be shown.
Mm-hmm. All right, well, once again, I appreciate the clarification on these matters. Of course, we did not have guidelines to help us to negotiate all of this, and we simply tried to interpret what we were given in the less than a week to respond to this.
It's in the ordinance. It's in the ordinance.
Yeah. All right. So this is, again, to the best of our interpretation, and by looking at the petition that Murphy Oil presented, we're responding to the things that they claim are benefits to the area. So, for example, Murphy Oil asserts that by staying open late, it provides food for those who work late shifts. And Murphy Oil specifically invoked the highly admirable professions like firefighters, police officers, medical workers, intending to convey that providing food at 2 a.m. to these people, they were providing a benefit to the community. So part of our response is that there are plenty of opportunities for this that already exist in the neighborhood, in the area, food trucks and the like. And that presenting this as a reason for this gas station liquor store to the area does not constitute a benefit that outweighs some of the other things that we've tried to address, such as the additional traffic, environmental concerns, and the like. Murphy Oil also has asserted that creating this particular business in this spot would bring a significant number of good jobs to the area, increasing employment opportunities in the area. They did not, in our interpretation, however, note how many jobs they expected to bring to this site, but the average number of employees at gas stations in the United States, according to what we could find, is about 7. If they doubled the average, that would be 14. However, Murphy Oil's own information on their website about employment opportunities states, and I quote, "Small in size, many Murphy USA locations make entry-level employees responsible for the entirety of the store during any given shift. Workers who enjoy solitary situations and comfortably handle several tasks at once in fast-paced environments make ideal candidates for store associate positions. Due to the large volume of responsibility and pressure associated with entry-level positions in the company, many stores experience high levels of turnover, which ensures the frequent creation of newly available jobs.
Mr. Benz, what are you reading from?
This was from Murphy Oil's website.
Okay, that's not in the record.
No, it's not in the record. This is something that we've since located.
Okay. I mean, I don't want to, I don't like to remand matters back to the ZHE if it's something I can resolve for the city council. I don't know how that is important here because you didn't supplement the record with it. I would like you to move on. I don't think that is relevant to the issues in this matter because the ZHE didn't consider it. And remember, the burden is on you to show me how the ZHE erred. I think that's really what you should spend your time showing me. I mean, you're welcome to use your time for something else, but it would behoove you to, if you really want to, make your case, would stick to the issues that are required to be shown.
All right. Well, what I would say in that regard is that that was not made clear to us prior to this hearing. So the presentation that
it's in the IDO, sir. It's clearly stated in the IDO. I mean, I don't know how more it could be clear. It's very clear. I mean, and I'm trying to give you as much leeway as possible because you're not an attorney, and I'm not trying to disparage you. I'm just trying to focus you onto the issues of this matter.
In that sense, I'd say that we've presented our case in writing. We've responded as best we can, and then I'll submit that and try to answer any questions that you might have.
Okay. Regarding the material adverse impacts, I read in your arguments that you believe that the noise issue, the air pollution, the fuel pollution, as well as the traffic problems at this intersection are material adverse impacts, correct? And it seems to me that the argument that the party opponents made in attempting to mitigate those adverse impacts were findings that the ZHE made. That is, that he would limit the sale of alcohol to a certain time period. I don't remember what that was, but it was, I think it ended at 8 p.m. at night or something, 6 a.m. No alcohol sales between 8 p.m. and 6 a.m. At night, which is significant. I've never seen that done before. He also required other mitigation matters. One thing he didn't find was that the conditional use permit was going to run with the land. He needed to make a finding of that. I saw on the record where he made I don't know if it's an argument, but he recognized that the applicants agreed to a condition that the conditional use permit not run with the land. What that means is that it would just be for Murphy Oil. It would not be for anybody else. So if Murphy went out of business, they would lose the conditional use permit. That is legally enforceable in the courts as long as there is a finding for that. And he didn't make that finding. Do you have any comment on that issue?
I do not.
Okay. What about the other mitigation measures that the ZHE found? Do you believe that those were in error, or do you believe they weren't enough, or well?
The only concern that the neighborhood has, or the main concern that the neighborhood has in that regard, is how enforceable is that? We don't understand whether that is something that's, if a year from now we go over and find alcohol sales at 10 p.m. In the Murphy, what can be done about it? Is this what's the
It's actually very enforceable. I'm also the liquor hearing officer for the city of Albuquerque, so I hear these applications for liquor licenses, and if the liquor hearing officer, as a matter of law, doesn't have the authority to mandate those conditions, the condition that alcohol cannot be sold at a particular time. That's a state preemption issue, which means the state has control over that, and they did not delegate that to their liquor control hearing officers. However, the zoning regulations and the interpretation of zoning law by the courts give the municipalities greater regulatory, I guess, conduct. They're allowed to regulate this thing, the time and sell, the time for when alcohol can be sold under the conditional use permit. That is enforceable by the courts. So as a liquor hearing officer, I can adopt that, but not as something that I've done, but as something that the ZHE has done. So it's very enforceable. My first thought was, how can this be enforced? It can be enforced by basically, if you find that this is being violated, you call the state, you call the planning department, and you file a complaint. You can file a complaint with the state, because this is this conditional use is enforceable, and all the conditions of the conditional use permit are enforceable. So yeah, I think it's very enforceable. So I normally don't answer questions, but I think that's a very, very good question you have. So, is there any other argument you would like to make regarding the ZHE's decision?
Not at this time, thank you.
Okay, and you have some rebuttal too. You can rebut the party opponent's arguments, okay?
All right, thanks.
Thank you. Mr. Chavez, Ms. Williamson?
Yes, Hearing Officer Chavez, we appreciate Mr. Benz and the concerns of the Neighborhood Association. We believe that today the appellant did not meet the burden of proving that the zoning hearing officer ruled erroneously. Accordingly, I'm going to have my witness address some points that were brought up by Mr. Benz and what was brought up in their application.
I appreciate that. And you're already sworn in, ma'am, so go ahead and proceed.
Good morning, Mr. Hearing Officer. Again, my name is Angela Williamson, and I'm the owner of Modulus Architects and Land Use Planning. I'm not an attorney. I did write the submittal that you are reviewing here today. I'm not here to defend all convenience stores, but I am here to defend this submittal, this operator for this location. We stand by the record in the decision of the zoning hearing examiner that we did meet the burden of proof. And if it's okay with you, Mr. Hearing Officer, I would like to go point by point, if that would be appropriate, on their application.
It's up to you, ma'am.
Okay, yeah. Okay, so I'm just going to go in order of the responses that they provided in their appeal application. The first point that they make is that I misname and provided wrong information regarding the Tower Bridge corridor.
I think that if there was a misnaming, I don't think that's a relevant matter. You can skip that.
Okay, so in their statement, they state that the kind of business that impedes the Tower Employment District Plan would be a convenience store. That's actually not correct. Specifically in Table 5-15 of the Comprehensive Land Use Plan, it specifically states that the Tower Employment Center prioritizes commercial development, prioritizes industrial employment, and discourages residential uses. The next point that they specifically state that the application was disingenuously claimed that a gas station or mini mart selling alcohol revitalizes the community and encourages employment density. By building a new Murphy, and the site construction in and of itself satisfies the requirement for development, the Murphy will bring new jobs and an average of $1.28 million in taxable revenue. The next point that they state is that they find that my fact that the availability of day-to-day goods and services without the need to cross the river is false. That's actually also incorrect. It specifically states, they say that my assertion is blatantly untrue. It is documented fact and policy in the Comprehensive Land Use Plan that clearly states in policy 6-1-3 to reduce the need for automobile travel by increasing infill development within centers and corridors. Table 5-7, and this is a direct quote. It states that by striving for more jobs and services west of the river is a major priority for the region where people can access nearby goods and services, which improves the quality of life for residents west of the river. This is a quote found in Table 5-7 of the Comprehensive Land Use Plan. The next point that they make is regarding, the federal banking laws in which it restricts FHA mortgages within 300 feet of a tank full of explosive material. That's their words. That's actually incorrect. My firm just happens to be HUD certified, and the actual statute states, and I have that here, this is from the U.S. Department of Housing and Urban Development. The statute actually states, and I will read it.
Can you cite to the statute first?
I don't have the site number. I just pulled it off their website.
Okay. It might be problematic to cite it.
Okay.
Mr. Hearing Officer, can we cite to it? We don't have the actual site right now. I'm going to look for that as we speak.
Certainly, I appreciate that.
Thank you. Again, I'm not an attorney, so I apologize for that. But the U.S. Department of Housing and Urban Development states that an FHA insured mortgage would be ineligible if the subject property is within 300 feet of an above ground storage tank with a capacity of 1,000 gallons or more, et cetera, et cetera.
Let me stop you there. Mr. Chavez, you don't have to look for the statute. That's actually in the handbook.
Thanks, sir.
There is a distinction between below ground and above ground.
Thanks, sir.
Thank you, sir. So that information is incorrect. Murphy's tanks are never above ground. They are all underground in double wall lined tanks. Excuse me, I lost my place.
It's probably a HUD rule. I'm guessing it's not even a statute. It's just a rule.
Yes, sir. Again, not an attorney, but yes, sir. So the next point that they state is that, excuse me, let's see, that change is encouraged. These are their quotes. In their response, they stated that change is encouraged, which doesn't mean that all change is encouraged. The Comprehensive Land Use Plan actually states that employment density, compact development, redevelopment, and infill development in centers is the most appropriate per Table 5-27 of the Comprehensive Land Use Plan. In fact, they state that residential would be more appropriate. The plan actually states and specifically identifies single-family residential as not being encouraged. So that information they provided is incorrect. The next submittal that they made is in response to unsupported assertions without proof. As it relates to the Tower Employment Center, the Comprehensive Land Use Plan clearly identifies this site and the IDO as an area of change, designated on a major transit corridor, designated in the Bridge Tower corridor, and in the Southwest Mesa planning area. They specifically state that this use would not be appropriate for this, and that's actually incorrect. These are the most appropriate identifying markers of a convenience store that offers the day-to-day goods for the neighborhood.
And what's the basis for that?
So the Comprehensive Land Use Plan states that a designated, and I quote this in my submittal, I quote the policy, that designated major transit corridors. Hold on, I'm a little bit behind here. And that's in my submittal, my original submittal, all of these policies that I'm quoting. They state, and this is their assertion, the subject property is located in an area of change and will direct growth with more intense development to this corridor where change is encouraged because the proposed request will encourage growth and high quality future redevelopment in according with the transit corridor policies of the Comprehensive Land Use Plan. That was my statement. They responded that change is encouraged does not mean that all forms of change is encouraged. The assertion about growth and high quality future development is unsupported by data because it is clearly refuted by data. Meeting a burden of proof requires more than an assertion. Again, I cite policy 8-1-2 that encourage economic development efforts that improve the quality of life for new and existing residents and foster a robust and resilient diverse economy in a transit corridor. So those policies are all cited in my original submittal.
Okay, I apologize. I thought you had said that a convenience store / gas station is most appropriate in a transit corridor, and that's why I asked for the basis for that statement. And I mean, theoretically, I would agree with you, and I know the comprehensive plan pretty well. I would agree with you theoretically, but I don't think there's specificity in the comprehensive plan, and it's meant to be that way. So I would just thought you had more data that would point to a convenience store gas station. Certainly the zoning allows it permissively, but I thought you had something else, but that's okay.
No, sir, but I said convenience store. It specifically says goods and services.
Right, that's, yeah.
So, and they say that they are refuting that policy. The next policy that I quote that they find to be inaccurate, this is my response, and is that the request allows for future development of the property, providing an incentive to business to expand and diversify employment, promote local hiring, higher wages, and businesses that contribute to the economic base of the community. Their application responds that there is no reliance on government spending in this corridor, so it cannot be reduced, and that a gas station and a mini mart selling alcohol does not truly diversify employment. Virtually every business in this corridor requires the same skill set, and that a gas station and mini mart selling alcohol does not promote higher wages. The petitioners, this is their application. The petitioners.
Let me interrupt you just a second. I apologize. You know, I think it's okay that you continue to make your record. Mr. Chavez will tell me that we need to make our record here, so you can do that. But you know, I never step in the shoes of the ZHE unless I believe that he erred in some way, and so I guess it's your burden to respond to the allegations of error. I mean, the nitpicking with the comprehensive plan and how we interpret that's very subjective. And so, and the ZHE knows that. And so his findings are objective findings based on the subjective, very general wording of the comprehensive plan policies and goals. And I mean, it seems to me, because this is a transit corridor, that many of the comprehensive plan's goals and policies support this goods and services type use. If you could respond directly to the other more important allegations that the appellant has made regarding the alleged misrepresentation in the void analysis. I mean, I would like to hear that, but certainly continue to make your record. I don't want to stifle your presentation, but if we could move on a little quicker on those.
Sure, absolutely. As it relates to the marketplace void analysis report, this report was provided by Maestas & Ward, which is a professional real estate company. I provided, and it's in the record, an analysis with an image and an identification of all the liquor retail opportunities.
Where's that in the record? Can you tell me by any chance? I know that it wasn't bait stamped. Do you have like a PDF computer version? That's the only way to really keep track of this.
Yes.
Okay, can you tell me where it's at in the record?
This was submitted as part of the prior to the second hearing when we were deferred. I submitted it.
So it's part of your supplemental. Is that what you're saying? Your supplemental narrative?
Yes, sir.
Okay, I know where that's at. Okay.
And so this was submitted this was provided by Maestas & Ward Real Estate, which are real estate experts, with the images and the location. We don't agree with their information. as far as the locations being misrepresented. As far as our information shows and what's submitted in the record, there is one liquor retail opportunity within a 1.5 mile radius, and that the average number of liquor retail opportunities in Albuquerque per 1 mile radius is 5. And I just want to note for the record, as you know, that there are no distance separation requirements.
There's not a density restriction, and there's the only restriction is the state's quota system, which the city theoretically could use as a basis to regulate through zoning, but that's questionable. So, okay.
And as part of this void analysis report, it contained more information other than just other retail liquor opportunities. It went over information such as our distance, to your point, greatly exceeds the strictest legal liquor distance separation laws in the United States that we could find. Our site exceeds the most restrictive that we found was 2,500 square feet. Our site exceeds that by 4,892 square feet. And we went over information such as the density restrictions of population to liquor establishments. And one thing I would like to note is, so best practices for municipal regulation to reduce alcohol-related harms in terms of meeting a burden of proof. They've cited 7 items that can be used that are the best practices for regulating conditional use as it relates to alcohol. And the first one is the properly zoned commercially, which this property is. This use is actually a permissive use. It became conditional because it's located within 500 feet of a residentially zoned property. The next is the spacing requirements from playgrounds, schools, or hospitals. The appellant stated that there's a church across the street. We went to that site and took pictures and submitted those as part of the record. That church is actually closed and boarded up, and there are no playgrounds.
Ms. Williamson, do you know the distance between the church and your proposed use?
I don't know the exact distance, no, sir.
Okay. Do you have are you transferring a retail license to this? Assuming it's approved, are you transferring a retail license to this facility?
Mr. Jerry Ham is our liquor broker, and he's working on that. I don't handle that portion of the submittal.
So he would, I mean, you said Mr. Ham?
Yes.
Correct.
Okay, so Mr. Ham would know if a waiver is necessary or not, and he's dealt with that quite a bit. So, okay, that answers my question. Thank you.
You're welcome. So the third thing is distance requirements between outlets. Although New Mexico doesn't have that requirement, the standard for conditional use is that there are no more than 4 alcohol outlets per 1,000 foot radius of each other.
What standard is that? That's not a New Mexico standard.
Oh, sir. This is the best practices of municipal regulation as provided by the Center for the Study of Law and Enforcement Policy, a national go-by standard that help communities figure out how to regulate alcohol-related uses. The next thing that they identify is restricting hours of operation. You will note that in our application and then in our hearing, I was given the authority by Murphy to voluntarily agree to restrict our hours of alcohol sales, which is not done in any of their other locations. But in this location, we felt that would be appropriate.
More than voluntary, didn't the hearing officer actually find as a condition that he set that the hours be restricted to the daytime hours?
Yes, sir. He did find that as a condition, but we voluntarily, prior to his notice in my presentation, said that we would agree to. We offered that, and a lot of that came from my discussions with the neighborhood residents months and months prior to our application about their concerns. Okay. The same for the next policy regulation opportunity is having no miniatures. Again, we volunteered not to have miniatures, and then even volunteered not to have any hard liquor at this location. That was not imposed by the zoning hearing examiner. it was imposed, but we actually volunteered that to the neighbors prior to ever making our submittal. And that was in our original submittal, that we voluntarily were restricting this on our, imposing that on ourselves. And that's in our application.
I apologize for interrupting you again, but I just want to clear something up, because that condition is not in the ZHE's findings. He
Yes.
didn't set the condition that the only condition he set on the type of alcohol is the miniatures, which is already in the IDO. But you're saying you're voluntarily agreeing to go further than miniatures. You're agreeing to restrict spirits, and so you're only going to sell wine and beer at this location.
That is correct.
Okay,
And that is
so,
in our application.
so if I find, and I have 15 days, and I take 15 days to look at this stuff. If I find or recommend to the city council that the ZHE did not err, and I included that condition as a harmless error issue that the ZHE failed to adopt, you would agree to that?
We will agree. We already agreed to that, and I forgive me, but I do believe it is his finding.
Oh, it is? I thought it wasn't. You should have told me.
Beer and wine.
Okay, I don't see. Well, okay, only beer and wine. That makes sense. Yeah, sure. It's just not. It's not as clear as I would like to see it. I'd like to see it very clear. But yeah. Okay, I see that. Thank you.
And again, that wasn't. That was volunteered by Murphy long before we even made our submittal to try to address some of the concerns of the neighborhood. We worked extensively with them even prior to making the submittal. And then I submitted a great deal of information regarding the security protocol, the training protocols, the extensive efforts that Murphy takes to regulate this use with security cameras, training, their use of CPTED, which is crime prevention through environmental design. They follow all of those policies. In fact, this is also in the record. I met with the lieutenant from the mayor's crime task force regarding this crime prevention through environmental design. So all of this is in the record, and I feel that, I think that we did show that we met the burden, and that Murphy has taken every step to mitigate any potential harmful side effects or effects to the surrounding neighborhood. Things such as the employee training, strong internal policies, restriction of hours, the restriction of selling not only miniatures, but any sort of hard liquors, which I will say that Murphy has never done that before, but in an attempt to try to let the community know that we understand their concerns, we volunteered that. And the other thing I want to point out is that Murphy is not any operator, and Councilor Lewis himself, or Davis, I'm sorry, even stated that while most
Ms. Williamson, that's not relevant for this. Okay. Yeah, I think what's good for the goose is good for the gander on the political statement. So let me ask you a question, though. May I?
Absolutely, sir.
I note that I have to say, I've dealt with liquor establishments as the Lujo for 15 years now, and I've seen a lot of these cases, and they're always the toughest for me, because the neighborhood it makes some very genuine arguments and heartfelt arguments for stopping drunk driving and things like that. And so this is the most impressive ZHE decision I've seen in 15 years regarding these kinds of liquor establishments. The condition number 3 was with regard to the CPTED, which is the crime prevention through environmental design standards. And he mandated that Murphy follow the model of smart policing initiatives and adopt and comply with the CPTED. I've never seen that before. I reviewed your narrative that had those initiatives in the record, but I don't see that the CPTED is actually in the record. Do you have, is there a booklet of standards, things like that?
There are some
Other than the highlights, I mean, other than the points that you put into the record, I'd like to, because he mandated that you follow the entire model, I want to make sure that the model is in the record. Is that model available to put into the record?
Yes, it is available.
Could you please supplement the record as quickly as possible within the next 3 days?
Yes.
By not sending it to me, by sending it to either Mandy Hedonis or Crystal Ortega with the City Council office, and they will forward it to me. Send a copy to Mr. Benz as well at the same time, because I'd like to look at that further. I have to say that in dealing with the last one, which was I think in 2019 with Circle K, I believe it was Circle K, and my recommendation to the City Council, I don't even know if they followed that recommendation, but my recommendation to the City Council about that that proposal was that the applicants were very cavalier about their application, and they didn't supplement the record with materials that would support mitigation. They just basically made broad statements that they have security measures, things like that. But you've connected the dots, and I believe that the CPTED connects the dots for you for the mitigation measures to some extent. I mean, I'd like to review it further. And since you've allowed me to supplement the record with that, I will review it further. So, okay, go ahead. I apologize.
No, sir. I have two more points that I would like to make, and it's just to clarify for the record. The first one is regarding drunk driving. That is noted in their appellant, and per the National Liquor Law Enforcement Association, most people driving under the influence consume their last drink at a licensed establishment, such as a bar or a restaurant, or as a resident, as opposed to a store where they purchase their beverage. And then the last point is regarding the safety of the actual fueling and tanks and so forth. The EPA highly regulates fueling centers and underground storage tanks. Murphy follows, of course, or is required to follow all of those laws. And Murphy goes beyond what is even required by the EPA. They have double-walled underground storage tanks with corresponding leak protection and detection units that are monitored at their home office. So they go over and above what the environmental planning or environmental protection agency requires. And so I think cumulatively, when you look at all of the efforts that Murphy is willing to take to demonstrate that they will not, and as the language says, significantly create adverse neighborhood or community welfare. Cumulatively, I think that Murphy has demonstrated that they are an operator that is a good neighbor and that is willing to go above and beyond what is required by state law or by the city code in order to demonstrate that.
With regard to the traffic design, the ingress and egress, that's reviewed by the county. That's what I gathered from the record, or is that also reviewed by the city?
Mr. Hearing Officer, it's actually reviewed by both. It's reviewed by the city, and they are mandating a traffic study by a licensed traffic engineer, which we are doing. But because the bridge realignment project, which is a federally funded $24 million project, is being managed by the county has asked that they have an opportunity to review and approve our site plan, which they have reviewed and have weighed in on our design as it relates and corresponds to the bridge boulevard. So both agencies will be reviewing our submittal.
Specifically the right in and right out, I'm guessing, is the reason why they want that review, because you're very close to the realignment. I get that.
Yes,
okay.
With that, Mr. Chavez, do you have anything else?
No, with that, Mr. Hearing Officer, we would stand for any more questions you may have.
One more question regarding the condition you voluntarily advised the ZHE that you would agree to a condition that states that this permit would not run with the land. The ZHE did not put that condition in there. I believe that he meant to, but he didn't. You would agree to that condition as well?
Absolutely. For the record, Murphy does not ever franchise their locations. And so they are spending a great deal of investment in this property, and so they will agree, they have agreed to that condition.
Okay. I have no more questions. Mr. Chavez, is there anything else you would like to add before we go to rebuttal?
Mr. Herrenhauser, no, there's none.
Thank you. And Mr. Chavez, I failed to inform you that you had an opportunity to cross-examine Mr. Benz. Since Mr. Benz is a fact witness, I apologize. You do have an opportunity to cross-examine Mr. Benz and his testimony.
Okay, Mr. Herr, at this point, I don't believe we have any questions. We're letting the testimony stand for itself.
And thank you, sir. And Mr. Benz, you have an opportunity to cross-examine Ms. Williamson at this point before we go to rebuttal. And for purposes of clarity, you have an opportunity to rebut everything that Ms. Williamson said, but not at this time. At this time, your opportunity is just to ask her questions about her testimony. So if you have questions, proceed. If you don't, we can go straight to rebuttal. It's up to you. But don't mix the two, please, okay?
Thank you. I just have one question for point of clarification. I'd like to know which building or which structure you are referring to, Ms. Williamson, as the boarded up church. On what lot are you talking about?
So it was in one of my numerous communications with Athena from your neighborhood association. They brought the church up. So we specifically drove over there, and it's across the street from, I believe it's the southwest corner, and took photos of this church not being open. And we did provide, since they brought it up in an email to me, we did provide photos of this church as part of the record.
Okay, thank you.
Any more questions, Mr. Benz?
Just if I would like have further information about that, should I include it in the rebuttal or state it now about that church?
Well, I mean, you can make an argument regarding that church in your rebuttal, and I'll give you plenty of time, but this is just for questioning Ms. Williamson.
All right. Then no further questions.
Okay. Go ahead with your rebuttal now. I apologize. Thank you.
All right. In terms of factual information in the rebuttal, I just have the one point regarding that church, and it's really a point of information for everybody involved. The actual location of the church is the next lot to the south, not that boarded up structure that you're looking at. That's on the property that Circle K originally tried to acquire and put a liquor license on. The next one to the south is and you can see this on Google Maps, Iglesia de Cristo Miel. It doesn't look like a church. That's why I want to make the point. It looks like a kind of a prefab structure, but it is a functioning church and very active. I can hear their singing every Sunday evening. That's my only point of information. Otherwise, I would say on behalf of the Neighborhood Association, again, we appreciate this opportunity to present our case. We feel that the hearing officer has the sufficient information in the written record, and we believe that you are an astute and experienced interpreter of that information. So we appreciate the time and the energy that you put into that. Thank you.
Thank you, Mr. Benz. Thank you, Mr. Chavez and Ms. Williamson. We will go off the record. And by the way, Mr. Benz, I will have a recommendation to the City Council within 15 days. I'll send it to you simultaneously with Mr. Chavez and Ms. Williamson, okay? And then what you want to do is you want to check with the office of the City Council after that to determine when the City Council will deal with my recommendation. What they do is they vote on whether to accept or reject my recommendation. they have that total authority to do. Sometimes they accept, sometimes they reject. If they reject the recommendation, then it's set up for a full hearing. And so they continue as if this process didn't even occur, and they'll hear the appeal directly in a city council hearing. Okay. Thank you, folks. I appreciate it. I've learned a lot today. Enjoy your days. Bye-bye.
Thank you, Mr. Benz. Thank you, Mr. Hearing Officer.
Yes.
Thank you. Bye.
Bye-bye.
Bye, guys.